get into?
Yeah, no, almost 1.5 years. So it is a sort of an inaugural lecture for 2021-22 LLM batch, and of course, like, for everyone else. So first of all, Professor Prasad, we are very, very thankful to you that you've accepted our invitation. I wish, it could be in a physical format, but like, we are lucky that you readily agreed, and you have, so many of our students, ex-students, will have the opportunity to listen to you today. Professor Prasad definitely needs no introduction. We all know him, especially through his work in clinical education in India and the amazing work that Salgaocar College of Law has been doing in the field in clinical education. And of course, his constitutional law surveys. He's a regular contributor to Annual Survey of Indian Law, and he's been writing on Indian Constitution there, which is a ready source of critical study of constitution and a good reference point for us, who are interested in public law and constitutional law. Professor Prasad has been teaching at Salgaocar College of Law since 1996, and he had a brief stint at the Indian Law Institute as well, which was amazing because he did amazing workshops on CLE here. We know that ILI does not take clinical legal education seriously, but we definitely had. I remember two, and I think we also, because I participated in two workshop sessions, which were, one day long on clinical legal education, and how do we actually include a CLE pedagogically in our learning and understanding of law. So it was a big takeaway from me. I'm not going to read his bio, which is available online, and also because I don't want to eat up on the time. Yeah, but I just want to say this, sir, that this year in LLM, we have our two batches, two specializations, one in criminal law and the other in constitutional law. So definitely all constitutional law students are really looking forward to your talk, but it is also significantly important for criminal law students, because at least in the last 10 years, it has become obvious that the criminal law and constitutional law are interwoven. We are constitutionalism, and that is what the talk today is about: contours of constitutionalism. How do we actually check the power, the tentacles of power of the state, Indian state, you know especially in the current political, cultural, and social milieu, where we see that there is a normalization of violence, there is a normalization of abandonment of due process guarantees, there is also a normalization of anti-secular rhetoric, if I can put it like that. But at the same time, we see that in the last few years, Indian Supreme Court has come up with amazing decisions, in terms of privacy, in terms of sexuality rights, women's rights, and it has given like real fodder to the liberal document that the Indian Constitution is. So in this background, we are really looking forward to hear your thoughts on contours of Indian constitutionalism. So over to you, sir.
Okay, thank you, Latika, and good morning to one and all. I'm happy to back to teaching in ILI students. It has a sweet memories for us. So even though it's just a year stint, but I made a lot of friends and good students. I'll just share my PowerPoint, and in between, I may request you to respond because, as she said, I'm a clinical teacher. I believe in a two-way process, but unfortunately, we have certain limitations, and I'm new to WebEx. I don't know whether I will be able to see your chat when I'm making the presentation. But if you could use your mic if you want to share something when I ask, that would be nice. Um, Okay. Can you see my PowerPoint? Is that visible? Yes. Okay.
Yes.
Yes, sir.
So the first question would be, what is a constitutionalism? If anybody could respond, at least with your brief understanding, we all studied constitutional law in LLB level. What do you think? What do you mean by constitutionalism? Would it be different from constitution? Anyone you want to? Because Latika has already set the tone, what constitutionalism is all about. Usually we think constitutionalism is a kind of restriction on the power of the state. Yes, thank you, Rohit. That is what generally the people think. It is a supremacy of the constitution. So I thought, let me put two things together and say, when we say constitution describes the rules of a government and how the government should operate it. Whereas constitutionalism look at how to control this government with the constitution. So therefore, constitutionalism includes constitution, powers of the government, and the limitation of the government. For example, the limitation on the legislative power, we see Article 13, which talks about you cannot violate fundamental rights, etc. And there are some, we have inbuilt restrictions like the freedoms under Article 19, Clause 2 to 19, Clause 6 talks about so many restrictions. So there are many ways in which the Constitution imposes restriction. Then the Constitution, as Rohit said, is a supreme law of the land. Therefore, the state which is created by the Constitution also looks like supreme. But the constitutionalism believes in checks and balances. It also tells no absolute power to any part of the government like legislature, executive, or judiciary. And the most important thing with Article 14, 19, and 21, now we have brought in the rule against arbitrariness. That means if the government arbitrarily makes any law, that could violate the constitutionalism. So that's another aspect. And Constitution also defines the structure of the government, powers and functions of the government, whereas constitutionalism says the authority of the government depends upon its observation of the limits imposed by the Constitution. That means the government has an authority, but that authority is a legitimate authority only when you observe the limitations of the Constitution, right? So therefore, to put simply, constitutionalism is an idea that the government should be limited, and the authority of the government depends on observing those limitations prescribed by the Constitution. So if the Constitution is able to do both, then we would say our Constitution has a constitutionalism. Okay. So now let us look into in deep in understanding the contours of constitutionalism. Why constitutionalism? To say why constitutionalism, I would like to say there are two concepts in the constitutionalism. One is the negative concept, what we have described till now and very popular among the jurists is the negative constitutionalism, that the government power should be restricted. Okay. There is another line of thought which talks about constitutionalism as a positive constitutionalism. That is, it is not only restricting the state power, but also it imposes a positive obligation on the government to protect the liberties of the people. That means it is not just not violating your fundamental rights, but it is the positive obligation of the state to see that the fundamental rights are positively implemented. For example, right to life, Article 21, if you take, it says state shall not deny right to life, liberty, equality without procedure established. That means if the state doesn't violate your right to free life, is it sufficient? It looks only half of it. Is there a positive obligation on the government to protect your life? For example, if you don't have a food to eat, is it the duty of the government to provide you food, or simply say that I did not violate your right, therefore I am not violating fundamental? So the second line of thinking is that the positive thinking. Now, whether you want to use negative or positive depends upon how do you understand the concept of the state. What is the purpose of the state? For example, uh, the state is a legitimate institution because it is created by the Constitution. And why the state is necessary? This line of thinking is that state gets a legitimacy because of the Constitution to control the human behavior. That's why the law controls us what to eat, what not to eat, what to drink, what not to drink, whom to marry, whom not to marry, when to die, when to marry, how to marry. Everything is controlled, right? So the Constitution creates the state and creates the institutions of the state and distribute the power among the states. But while these institutions are acting, there would be an interlap or an overlap, what we call. Like legislature involved with the judiciary, judiciary with the legislature and executive. And Constitution creating these institutions, therefore, the institutions must honor the principles of the Constitution to become a legitimate state. That means if you want to be a legitimate state, because you are created by the Constitution, you follow the principles of Constitution, don't go beyond that. That's the idea. Okay. So this kind of line of thought is supported by the Max Weber understanding of the state. What he says is the state claims monopoly to use the physical force within a given territory because the Constitution gives you legitimacy. That means the state gets legitimacy of using force against its citizens. Therefore, the relation between the state and the members are domination and the subordination. That means the citizens are subordinate to the government dominates. Let me give you a very simple example. Because we are under the political state, if somebody slaps you, you cannot slap them back. You have to go and register a FIR with the police. So let us bring the criminal law, because Latika also said the criminal law and constitutional law is intertwined. Now, what happens when you go to the police station and complain, and the accused got information and comes and slaps you again because you had given complaint? Again, you cannot slap. If you slap, he will also go and complain and they will also file a case against. That means what it says, you cannot take the law into your hand. The enforcement of your rights is surrendered to the states. I always say that we are a sitting ducks because we are not allowed to have weapons. We don't have a right to retaliation because we are under the politically elected state. So imagine if so much power is given to the state, would the state exercise the power properly? What if the state misuse that power? That is why they say constitutionalism is necessary to control the power of the state. Means the state is going to control us in every aspect. So therefore, the challenge that we have is what are the ways in which we can restrict the state from exercising that arbitrary power? We are given so much power to the state and we are trying to limit the power of the state. It looks like irony, but that is what happens. How do we protect our liberties from the state? So one way of looking at it is this kind of power is given to the court by which the court through rule of law restrict the power of the state. Right? That is what we all understood under the judicial review. So therefore, in this sense, constitutionalism is nothing but constitutional principle limiting the state. So what are the principles in any constitution restrict the power of the government? Would be automatically a constitutionalism. Hence, constitutionalism becomes a synonym with the enforcement of constitutional limits. But please remember, constitution duty is not stopped or limited to bring the state into existence. Actually, constitution starts from the day state is formed and how the state is going to rule us in future. Okay, constitution duty is not over by creating the state, but it is further. It is. So beautifully, Thomas Jefferson explains beautifully why such constitutionalism. If you look at it, to quote, the two enemies of the people are criminals and government. So let us tie the second down with the chains of the Constitution. So the second will not become the legalized version of the first. It's a very strong statement, but it is true. If you don't tie the government, it becomes an organized criminal syndicate, right? And he also says when people fear the government, there is a tyranny. But when the government fears the people, there is a liberty. Now you apply to the present situation uh, who is afraid of whom. I will leave it to you because you are all adult. Uh, so therefore, as a constitutional law students and teachers and lawyers, we need to understand Constitution is not a document by which the government restricts us. It is exactly opposite. Constitution is a document by which we restrict the government. So that's why if you see all the government, the ministers, MLAs, etc., MPs, everyone swear on the Constitution that they will uphold the Constitution and become the MPs and MLAs and the ministers. And what if their personal agenda is against the constitutional principle? We have seen that in Shabarimala's judgment. As an individual, I strongly believe that women should not be allowed to enter into a temple. But as an MLA, MP, minister, prime minister, chief minister, or a police officer, I am bound by the constitution which talks about equality. Okay, so that is why Chandrachud brought that constitutional morality and all to guide us. I will deal with that at the end of the discussion about how constitutional morality becomes part of constitutionalism. Okay, so there are two dilemmas in the constitution. One is you are enabling the government to control us, and you are telling the government to behave itself. This is kind of a dichotomy. I'm giving you the power, I'm telling you don't exercise the power arbitrarily, which is different. Then why are you giving that power if you are telling them not to use it? Okay? So therefore, the question is how to control the government. We all agree that electorate is one control, but we know none of us, at least majority of us, doesn't vote based on the performance of the government, either religion, caste, money, political affiliations. So therefore, electorate as a control on the power of the government is not enough. That's why we need auxiliary controls as a precautions to be incorporated in the Constitution. That's one. The second one is, again, Thomas Jefferson has some idea about this constitutionalism. Is constitutionalism against the democracy? Now, what is democracy? It is the majority rule. Now, your constitution is framed in 1949 in ours, maybe in America more than 200 years. Why those principles will control the present generation, which is completely different? See, that means today we had given a majority to a particular political party. Why can't the political party run because the way they want? Because we gave the power to them. Why should they be tied down with the dead past? Dead past, I mean 1949 Constitution. So in 1949, your Constitution says be secular, but today majority of the people don't want secularism. Why should we tie it down with the age-old ideology? So therefore, in that sense, there is a line of argument that the constitutionalism is against democracy. That means it unnecessarily imposes old rules on the present generation. However, we would not be able to accept that kind of interpretation that the constitutionalism is against the democracy. In fact, it is exactly opposite. The constitutional constraints actually strengthen the democracy. And particularly a country like India, where this kind of diversity you see, no country has. Closest the diversity we have is in America. But America doesn't have 1.3 billion people. With 1.3 billion people, with the diversity, India is the only country we have in the world. In terms of population, China is more than us, but China doesn't have this much diversity. They don't have different religions, different caste systems, different regional problems, language problems. 95% belong to the same category there. So that is why a constitutionalism, though look like prima facie anti-democracy, but in fact, it is necessary for establishing it. Okay, so I'm going to give you 10 reasons why these constitutional constraints are required. And again, here we are still discussing the negative aspect of the constitutionalism, that is, restrict the power of the government because the government controls us, therefore we want to restrict the power. So the first one is a pre-commitment. Now, what is this pre-commitment? See, when the state came because of the constitution. That means the very existence of the state is being under the constitution. Constitutional document is a pre-commitment for the state to continue. Like when you are starting a job, what is the pre-commitment for a job? Your contract, job contract. Your job contract will tell you what are the rules and regulations by which you should perform your job. So constitution is kind of a contract, it's a pre-contract. So you all become government officers or ministers, etc. under the constitution. So you must abide by the constitution. You like it, you don't like it. That is the agreement for it. The second reason is we call as pre-political rights. That means individuals are born with rights. State came later, like right to property, right to liberty, like right of choice, etc. These are all there before the state was emerged. Hence, these rights, just because you have become a political group today, cannot violate those natural rights. It is loosely defined or tied up with the natural law theory that we born with rights, at least certain rights the state cannot take on. Okay? So therefore, the third principle that follows in the pre-commitment is the rights of the individual, regardless what majority thinks we should enjoy. For example, whether I want to eat a beef or not, what majority thinks, it doesn't matter. That's my right to choice, right? So that is what important. So therefore, the freedom of speech, association, voting, etc. These are the rights automatically recognized and even by state cannot take. And also constitution represents the will of the people. That's why we say we the people of India do hereby solemnly resolve India into etc. etc. So therefore, it is a long-term commitment that the constitution represents the will of the people. Hence, the pre-commitment restrict the political bosses who have a short-term passion, because my passion is after 5 years I want to re-elect. I'm not worried about the country future. My whole problem is after 5 years whether I'm going to become chief minister or prime minister. So that's why we want a long-term goals. Maybe direct to principles of state policy as a pre-commitment, because any government comes, any party comes, they should follow it. And the court was entrusted with this kind of power because courts don't have short-term passions, because courts are not elected. They are not responsible to the people, right? Therefore, the courts are in a dispassionately, they may decide the cases. That's why it becomes the protector of constitutionalism. That's the first point. The second point is enforcement of principal-agent relationship. Means the government is my agent, people are the principal. And we govern this relationship through the written constitution is the document, like you all studied under the agency, under law of contract, principal and agent is bound by the principal's directions. So we being the principals, the government should bound by the principal's direction, which is a written constitution. Okay. But there is a problem. Who would enforce this relationship? Because in principal-agent relationship, principal is in a higher authority, controls the agent, but here people in aggregate capacity will be difficult to control that relationship. Therefore, we give them to the courts. But my question is that what if the court failed to enforce? We have seen at least from last 7-8 years, how the Supreme Court has behaved and how much criticism that we have against the Supreme Court, unable to enforce the constitutional principles. This is one problem. Second problem is court is willing to enforce, but willing to enforce their own notion of fairness. For example, we have seen in the sexual harassment case against the Chief Justice, what kind of enforcement we have seen. That means they did enforce, but enforce their own notion of fairness, right? We have seen that Supreme Court is a champion of right for what we call transparency, but when it comes to Supreme Court, they said we are not under RTI. We have the same issue in Goa, whether Goa Governor's Office is under RTI. Strangely, Goa Governor's Office said they are not. And fortunately, the new governor who came, Mr. Pillai, I really salute him. He told them nothing doing, no contest in the court, give them the information, we are public officers. So that's the commitment that is required, right? So, and another problem with the court, this is the major contribution, or what we call criticism, is can a court enforce the principles of constitution when they are not representatives of the popular sovereign? Because they are not elected. Because elected is the MLAs and MPs. They are more responsible for the people, but you are not responsible for the people. How do we trust you? This is more or like the European style of arguing or the Western style of arguing, because they have very less faith in the court system. And the another one, as I already discussed earlier, why should we bound by the agency restriction designed by the people in 1949? 1949 people are different, 2021 we are different. This is another problem. And when we say that the government is bound by the constitution, is court also bound by the constitution? Is the court is also an agent? The answer should be yes. Because if you look at our preamble, socio-economic and political justice, who is supposed to provide that? Is the courts. But if the courts are not using socio-economic and political justice, particularly when there is a great migration and the court is not ready to even consider that there is a violation of the rights of the migrant workers, did the court fail to perform this agency relationship? We need to think. The third one is, of course, this everybody knows, I don't go into detail, that the Constitution provides checks and balances. This you are studying right from your 10th class, so I'm just skipping. Then, sorry, this we are discussed. Then protection of minority. Now, please remember, when I say minority rights, doesn't mean religious minority, etc. Minority means whose idea is not popular. Unpopular ideas. If my idea is an unpopular idea, I am a minority, because majority people think in different. For example, I am pro-abortion. Majority people are anti-abortion. I am a minority. I am pro-LGBT. You are against majority. Then I am a minority. So the Constitution, the idea of the fundamental rights are, they are beyond the reach of political majority. That means just because we are given majority to a political party, tomorrow, say for example, 550 MPs were given to one political party, can that political party do away all the rights of the citizens? They are not. Right? The courts have acted sometimes pro-majoritarian rights. If you look at the Constitution, at least from A.K. Gopalan to Maneka Gandhi, the Supreme Court is pro-majority. Even today, the Supreme Court is pro-majoritarian, because if you don't like somebody, arrest them under UAPA. Right? If somebody celebrate a win against India by Pakistan, legally there is no wrong committed, because constitutionally it is permissible for your expression. And they knew very well, either they slap sedition or UAPA. Right? And then what happens, the moment you are slapped with the UAPA, 3 months you can be detained without producing before the court. And even if you apply for bail and all, we have seen the different standards applied by the different benches in granting bail. That's very nice to look into the criminal law jurisprudence when bail is a right for everybody. How come some people get and how come some people don't get? It all depends upon whether your judge is a liberal judge, you get. If your judge is a conservative, you don't get. That's the problem. Uh, Sometimes the court do recognize anti-majoritarian rights. For example, in US, Brown versus Board of Education, where they talk about uh, separate but equal is a violation of equal. Roe versus Wade, where abortion was recognized, and Roma's case, gay rights were recognized. Similarly, in India, last few years, we have struck down adultery, we have struck down to some parts of Section 377. We opened the women for the temple entry. These are all anti-majority. So that means some places the court do anti-majoritarian rules, but some places they follow them. Then the fifth one is that continuity or tradition. That means the state has its role cut out. Who owns the state means who rules the state, which political party rules the state doesn't make any difference. They should follow the same principle. For example, whether it is Congress, whether it is BJP, whether it is AAP, Communist, doesn't make any difference. They have to continue what the Constitution asks them to do. That's why constitutionalism is required. Otherwise, what happened? 5 years of Congress rule, they bring one, and the next 5 years, BJP comes and completely undo that and start their own. And after 5 years, another person comes and do whatever they. Okay. Then the sixth one is symbolizing the national unity. Constitution as a national unity. That's what, if you look at, we are different people but united by the Constitution. We are different religions but united by the Constitution. We are not homogeneous, we are heterogeneous. Therefore, these constitutional principles need to be adhered, accepted to symbolize the national unity and integrity. That's why even we have an integrated judiciary where the same interpretation of the Constitution applies throughout the country. The next one is serving as an educational function. That means constitutionalism as an educational function. What does that mean? See, we all have religious values, we have our family values, but we also have a constitutional values. So what we need to do is we need to adhere to the constitutional values, even if the constitutional values are against your personal values or your ethical values or religious values. So constitutionalism brings that the constitutional values are supreme. That is the underlying thought of constitutional morality, right? So you need to shape the public opinion through constitutional values on whether it is reservation, whether it is the rights of the LGBT, whether it is rights of the temple entry, whatever it is. Okay, so constitution does bring values. That's why if you are constitutional law students or teachers or practitioner lawyers, I cannot accept you discriminating between your son and daughter. Though there is nothing wrong under the Constitution, because Constitution talks about discrimination by the state, not by private individuals. But if you say to your child, don't marry outside our caste, that means you are violating your constitutional values, even though you are not violating a law, right? So that means when I'm teaching Constitution, I should imbibe those values. So when you learn Constitution, you need to imbibe the values of the Constitution. The another thing is that the constitutionalism is also securing finality of the disputed issues. Now, what does it mean? Constitution doesn't settle your dispute, but Constitution is very clear that we have to be secular. Therefore, the moment you become a government officer, MLA, MP, whatever it is, you like it, you don't like it, you have to be secular. So it settles. Your dilemma is settled by the Constitution that you need to be secular, you need to be non-discriminative, you need to be tolerant because freedom of speech and expression is allowed. Therefore, anybody criticizes you, you must be able to tolerate it. Because the Constitution already told. Constitution tells you to be transparent, therefore you have to be transparent. Okay? The ninth one. providing rule for recognition of law for law. That means the legislative competency or legislative process is protected by the Constitution, the Constitution. So therefore, the constitutionality of law is the fundamental essence of the Constitution. That is, we all know that a state cannot make law that violates the fundamental rights, right? So therefore, this is the ninth one, and the 10th one is the majoritarian preference for constitution. This is a little tricky one. I know I'm going a little fast because I thought of finishing 40 minutes, giving you some time. This is connected to pre-commitment. When we say constitution is made by we the people of India, means the constitution is made by the majority people. So the majority of the people wanted constitutionalism to be part of the constitution, right? So therefore, you must adhere it. So we are bringing the democracy principle. What is the majority said you must follow? The majority people said follow constitutionalism by adopting a constitution. Hence, you must follow it. Then what about the minority rights? Because we have a discussion in the country when we already have Article 14 to 18 talking about right to equality. Why do we need Article 29 and 30? Are we becoming second-class citizens in our own country? We mean the Hindus. Okay? Because the thought that providing special rights to the minorities under Article 29 and 30 is giving a second-class treatment for the Hindus. That means the Muslims, Christians, and other religions are enjoying better rights than us. So what about that? So did the majority agree for the minority rights? So look at that dilemma. See, if you are saying that the majority should rule, majority being Hindus, it should have been a Hindu Rashtra. But we did not do that. What we did is we decided to go secular. Now look at the surrounding countries. India, surrounded by Pakistan, is not a secular country. Even Sri Lanka is not a secular country, it is a Buddhist country. Bangladesh, constitutionally secular, but we all know predominantly Muslim, right? And Burma is a Muslim country, and only China, I think, doesn't have a religion. So that's the only, of course, it's a communist country, so we don't go into that. Nepal is supposed to be now a secular country, but predominantly a Hindu country. So when we were surrounded by, most of them are religious states pro-religion, why did we secular? Why did we want secularism? Right? So that means the majority want secularism, therefore the people who man the country should also accept that secularism as a majority condition, right? So therefore, if just to give back to what we are saying, that because the majority want constitutionalism, the government must follow constitutionalism. Because the majority agreed for minority rights, remember that. The majority agreed for minority rights. The majority agreed for secularism. Majority stood for freedom of speech and expression. So therefore, if I speak something against the country, would that be against the interest of the country or not? It doesn't. It is immaterial, because as a majoritarian, we clearly mentioned under 19 clause 2, there are 8 grounds on which my speech can be restricted. So therefore, you cannot restrict my speech other than those 8. whether it is defaming my country, whether I am celebrating something which you think anti-national or so, it doesn't make any difference. For example, if there is a football match, the majority of the Goans would be supporting the Portugal. It doesn't mean that they are anti-national, right? And Sunil Gavaskar is more popular in West Indies than in India. So all West Indians are not anti-democratic, anti-nationals, right? So that is what we would look at it. So therefore, in a sense, constitutionalism promotes democracy because that is what the majoritarian people wanted it. So I identified few features of constitutionalism. Particularly, written constitution was very much hailed as a minimum requirement for the features of constitutionalism. Though we could see the British is still going strong without a written constitution, and do they have constitutionalism? But the majority of the principles now has crystallized into a law even in Britain. So therefore, I don't see any new country emerging will not have any written constitution. They all will have a written constitution. And written constitutions are far better because the human manipulations could be limited. I'm not saying that you cannot limit human manipulations. Like the Supreme Court has manipulated in appointing the judges. If you read the constitutional text, it is the president in consultation with the Chief Justice. Now that has gone now, and the Supreme Court is appointing its own judges. That is a clear manipulation of a written text. Good or bad, I'm not talking. I'm just saying that there is a process, right? But written constitutions gives more safety and more protection to the constitution. Separation of powers, corrupt powers, people, absolute power corrupts absolutely, judicial review, fundamental rights, rule of law, jurisdictions, independence of judiciary, even amending power. How amending power is a supportive of constitutionalism, because through amendment you are changing the constitution. But the process for amending the constitution is rigid. So that rigidity of amending the constitution shows how it is a restriction on the power of the amending the invention of basic structure becomes part of now constitutionalism, because the state cannot amend the constitution which violates basic structure. Even constitutional conventions like who could be a prime minister, etc. Because there is no provision under the constitution that majority party leader should be the prime minister. It's just a constitutional convention. And then the constitutional interpretations like basic structure, etc. Basic structure, then we have this golden triangle between 14, 19, 21. These are all becomes the part of constitutionalism. So these are the negative aspect of constitutionalism. That means whoever believes that the duty of the state is to control the human behavior because they get the power from the constitution, hence there should not be absolute power given to. Okay. Now let us go into the positive concept. The positive concept of constitutionalism. So here we need to look at the Aristotle understanding of the purpose of the state. The Aristotle says the state exists for the purpose of well-being of its members. So the purpose of the state is not to control your behavior. That is, it is not a police state, not a laissez-faire. It is a welfare state. So he says a state that fails to advance its people's well-being is not merely a state that acts badly, but an institution that has failed to achieve its defining point. That means if you don't look at the betterment of your people's well-being, you are not only a failed state, but you failed core thing why you are created. So he gives an analogy of like when a patient go to the hospital, the very purpose of going to the hospital is to get treatment. And if the hospital fails to treat the sick, it is same as the state failed to protect your well-being of the people. So that means the domain of the state is not restricting you, but the domain of the state is to see that your welfare, right? Hence, therefore, in this aspect, the constitutionalism is not only to limit the power of the state. Rather, it is creating the institutions of the state in such a way that it functions in a successful way to protect the welfare of the people. So constitutionalism imposes a positive obligation on the state to protect the welfare of the people. That means the constitution should structure these institutions in such a way they perform their duties, functions, obligations for the benefit of the people. Okay? So that is what we expect. Hence, the constitutionalism is nothing but creating an effective and competent set of institutions. Whether it is Controller of Auditor General, whether it is Election Commission, it doesn't make any difference. All these institutions must be effective. So, what we expect is the state proactive role in protecting the liberties of the citizens. Hence, here I want to ask you one question. Whether the state role should be restricted from violating the fundamental rights, or the state role should be proactively see that the fundamental rights are protected. Whether you want to go with the first one, you can type 1 or 2. 1 means you want that the state should not violate fundamental rights. 2 means you think that it is not only not violating fundamental rights, it also to uphold the fundamental rights of the people. Positive. Can I have some quick responses? Okay, 2. Gurumit says 2. Okay, Harshita 2. 2, Rohit. Okay, you go on typing. I'll give you an example. I'll give you one example. Say, for example, this. I hope you remember there is a movie called Da Vinci Code. That when the Da Vinci Code movie was released, there was a lot of objections from some of the Christian minority people. And they went to the court, censor was given the censor certificate, went to the Supreme Court allowed its exhibition. But there are in some states, including Goa, there were threats against the theater owners. If they show that movie, the theater will be burned down. Now, is there a positive obligation on the state to provide the security to the theaters and to the people who wanted to watch that movie? Or simply say it's a private matter, we are not violating the principle of speech. So this is the dilemma. Because I remember in one of the state, I don't want to name the state, when somebody asked the home minister that there was a threat given by their own MLA, that who is a Christian, who is going to burn down the theater if they allow the exhibition of it. And the home minister's response is, it's a private matter, we don't interfere. That means I'm not violating your right. If your private person is violating your right, but there is a duty on the part of the state to see that they exercise their right to speech and expression. I'll give you another example. Suppose I'm making a speech, my speech is an unpopular speech. Majority of you don't like it. For example, I am very critical about a religion. Okay. So in my speech, I started criticizing religion. The people who are religious started pelting the stones and causing damage. Now, what the state should do? The state should arrest the people who are throwing the stones, or the state should arrest me from and prevent me from speaking. Could anybody want to say? One or two? First one is arrest the stone pelters. Two, stop me from speaking. Oh, everybody is saying one. But actually, what happens in reality? In reality, it happens as two. Yes, but practically two. We don't want, see, for example, I would give you this dichotomy, even with the liberals or the leftists they have. Say, for example, if Ramchand Guha was not allowed to speak because he's going to speak against culture, whatever it is, because the fundamentalists don't allow him to speak. But the leftists also don't allow Ramdev Baba to come and speak in their campus. Both are wrong. See how much right Ramchand Guha is having, the same right Ramdev Baba is also having to say his rights. Right? If I have a right to criticize the religion, you have a right to praise your religion. So therefore, the positive constitutionalism is very important for us to understand that it's the positive obligation of the government to protect the rights of the people. Otherwise, what will happen? Let me give you this example. I, for example, as being a professor of law, and I cannot say all girl students will get 1 mark extra in my internal assessment. Boys will get 1 mark less and girls will get 1 mark. Or the vice versa. All boys will get 5 marks extra. It is a discrimination not allowed because I am a public functionary. I cannot do that. But I will go home. So that means in the class, I am absolutely equal between the girls and the boys. But when I go back home, I would put my daughter in a government school, but put my son into a private, very good private school. It's a clear discrimination that I do. But unfortunately, constitutional principles will not apply because I am no more a public functionary.
So 1 second. So there's some disturbance. Amit Ghosh, can you please switch off your? Can you mute yourself, Amit Ghosh? Amit Ghosh, can you please mute yourself?
Yeah, I think he is done. So that means I live a dual life. As a public officer, I completely live under the constitutional norms, but as under a private, I clearly violate, right? Say, for example, I'm a registrar of marriage. I cannot refuse a marriage between a Hindu and a Muslim couple, but if is my daughter wanted to marry inter-religious marriage, I try to stop. Amit, I just lost your this thing. I couldn't read completely. I will answer that after I finish my this thing. So that is what is going to happen if you don't follow that positive constitutionalism, that we live a dual life. Okay? So therefore, look at this. I had given 3 examples. You can take many examples. Right to equality, whether only the state should protect right to equality or individual also protect equality. Now, if you look at the impact of the Constitution tells all public servants must follow constitutionalism, but the private individuals, they need not. That means the private individuals are supreme to the Constitution. Constitution cannot control them, in a sense, right? Though in other sense, you have a right to choice and choose, that is different. But the other way around, if you look at, a constitution can control the prime minister from discriminating, but the constitution cannot control an individual from discriminating his wife, daughter, son, because there is no private law unless you bring a private. Similarly, freedom of speech, whether it is the state should stop only speech problem. Our state should also proactively protect your speech problem. That we have discussed the case of Da Vinci Code. Similarly, right to life. State shall not violate your right to life, yes. But is there a positive obligation on the state to protect your life from material abandonment, from material wants, food, shelter, clothing, whether it becomes part of the constitutional right and obligation of the government? So if you take constitutionalism as a positive concept, they become part of constitutional principles. So therefore, the positive constitutionalism is higher, broader compared to negative constitutionalism. So for me, both are important. So you need both negative as well as positive constitutionalism. Now coming to this aspect, I just couldn't resist my temptation to add constitutional morality, because this is going to be the next big thing after with Keshwananda Bharati's case, where we have brought the basic structure. This is going to be another biggest controversial doctrine. So if you see, initially this constitutional morality was invoked in fundamental rights cases. But the judgment I had given in Government of NCT of Delhi versus Union of India, where Chandrachud brought this even into the other parts of the constitution. Okay. What if tomorrow the president doesn't follow constitutional principle? Would that be violation of constitutional morality? So that's going to be a big thing. So constitutional morality, according to the Supreme Court, says in strictest sense, strict and complete adherence to constitutional principles that was mentioned in the document. Okay, if that is what we are going to do, that means every member of the country, whether you are an MLA, MP, or a citizen, must idolize the constitutional fundamentals. That means it is not restricted only to the constitutional functionaries, but also for us. Why I say that? As an individual, if you don't accept constitutional rights, you would never do the same when you become a minister or an MLA or a public officer, right? Unless you imbibe those constitutional values, you will not. That means you expect us to be unreasonable, but you expect the politicians to be reasonable. That is unreasonable expectation. So we also should be reasonable and they also should be reasonable. For example, when you say if the court has decided that the temple entry is allowed, even though we may not accept that, we should abide by it because the constitution permits it. Though I do agree that the constitutional functionaries have a greater degree of responsibility compared to citizens because they swear on the constitution and they are the constitutional functionaries. Okay? And they derive their power from the constitution. Hence, it becomes their duty to cultivate among the people the constitutional values. But if you see, the most of the politicians are exactly opposite. They openly defy the constitutional principle. There could be a possible reason for it, because in the election they did advocate the same principles against the constitution and won. That means the majority of the people agreed that they don't want the constitutional principles to be followed, right? If I say that I'm going to construct a temple if I win in this election, it's a people mandate. How can you refuse that? That cannot. Or suppose I say, if I come to power, the first signature would be on prohibition of liquor, right? So, but the court says prohibition of liquor is violation of Article 19(1)(g), 19(1)(a), and 21 tomorrow, because it's still pending before the court, right? Like beef eating. Suppose tomorrow I say, if I come to power, I would bring a law prohibiting beef. But constitutionally, the court says no, it's their fundamental right. How are you going to reconcile? So that's why Whether you are an MLA, whether you are an ordinary citizen, you must imbibe. And the duty of the MLAs, ministers, and all is to cultivate and develop the spirit of constitutionalism among the. So this is my last quote. Look at that. Ambedkar has thought about this. The constitutional morality is not a natural sentiment. It has to be cultivated. We must realize that our people are yet to learn it. Democracy in India is only a top dressing on an Indian soil, which is essentially undemocratic. So we are not basically a democratic people. Look at your own family. Forget about ours. I give you a simple example with my daughter. She was very young, about 4 or 5 years old. We were going for a marriage. My wife wanted her to be dressed with a special dress. She refused, saying that I'm not comfortable with this dress. I'm comfortable with a t-shirt and a short. Why can't I go? Reasonably arguing. And what we say, shut up, we are elders, listen to us. Right? So that means essentially we are not democratic. And the democracy was thrust on us. Therefore, constitutional morality is going to be a larger issue in future. To what extent this constitutional morality is going to take us? Because if you see, Article 15 is going to be a biggest challenge. The constitutional framers know that there are social discriminations, inequalities, etc. In spite of knowing, they brought Article 15. So now the question is whether Article 15 was brought to eradicate those social evils through constitution or not is a debate. Of course, till recently, the Supreme Court was not accepting that, saying that they knew very well that there are these differences, but they put 15.1 or 15.234 not to make constitution as a vehicle through which you want to achieve it. It has to be through political process. That's why initially the Supreme Court refused to recognize personal law as the law within the meaning of article fundamental. No, I don't see public morality and constitutional morality is one and the same. Public morality based on your society, your values. Constitutional morality based on constitutional principles. Let me give you the example of whether a menstruating woman should be allowed to enter into a temple. Forget about Shabarimalai, but any temple. The public morality is no. Public morality says you should not, because that is what the religion told us. The woman would be impure during the menstruation, so should not be allowed to perform pujas, not to allow. It is a religious perception, essentially a religious thought. But that doesn't stand to the constitutional reasoning. But my worry is, and of course my dilemma is also, if you go on bringing rationality, not a single religious practice will stand for rationality. Right? See, when you do arati like this, somebody says, why can't I do like this? Why clockwise or why not anti-clockwise? Why can't I wear chappal and enter a temple if you can allow in churches? Right? There is no reason. These are all practices. It's very difficult. So in that aspect, the American courts have followed two principles in case of religion. The first principle they say is the freedom of religion is absolute in terms of believing a religious practice. That means you can believe a religious practice in absolute terms and nobody can stop you from believing. For example, sati. I can firmly believe sati is a good religious practice. But when it comes to the implementation, it is not absolute. That means believing a particular religious belief is absolute. You can believe any crap, anything, any nonsense, any superstition, it's fine. But when it comes to implementation or practicing of that belief, If it is substantially violating somebody's right, etc., then that should be controlled. So therefore, I can firmly believe that the women should not enter into temples, fine. But if I practice that, it is going to violate the rights of the somebody. Therefore, there the court can interfere, the state can interfere. If you read that Young Advocates Association case, particularly the women judge, I forgot her name, she says, sati should not be allowed, but menstruing women should not be allowed to enter into a temple is fine. That means sati is a higher evil, this is a lesser evil, therefore we should allow. Right? But how do you decide what is lesser evil and what is not? Ultimately, the judges. What it is told by constitution, but what is constitution is told by the court. Right? So ultimately, this constitutional morality is going to be individual based interpretation. We are very much pretty sure if it goes to Chandrachud, we know that we get the maximum liberty, liberal interpretation. But if it goes to somebody, it may not. This is the same when Krishna Iyer was there. We all know that if it is socio-economic rights, the Krishna Iyer is going to outright support it. So that is going to be a challenge that tomorrow, particularly if anybody has not read this case, this Maharashtra Hotel Association's case on dancing bars, and Justice Deepak Mishra has given judgment using constitutional morality, there's a complete what we call contradictions. Say dancing bar, women dancing in bar is a fundamental right under 19(1)(g). And he says, don't bring your public morality into here. It is a constitutional morality. But the same judge says, you cannot shower the coins on the women. That is derogatory. That means you are bringing the social standard. Same way he says, up to 11:30 they allowed, after that they are not allowed, fine. But the bar is allowed up to 2 o'clock. Why can't they dance till 2 o'clock? So there are a lot of things. So therefore, one side you want to be liberal, but at the same time, your society pulls you down. Then therefore there is a conflict between these two. So how it is going to come in future, we need to see. Okay, I'll stop here. Maybe I'll take few questions.
Thank you so much, Professor. Thank you so much. I can just say this, you already would have seen in the comments that, we all found this talk very, very thought-provoking. But I just want to say this, that we desperately miss you at the Indian Law Institute. And we really, and I mean, anyone who is interested in constitutional law would, and who has occupied ILI as a space while you were not here would vouch for that, It has been absolutely a thrilling political and constitutional critique that you have given of notions like constitutional morality. I was thinking that where are you going to take it? Are you going to stop with Chandrachud? But it is amazing that you have foregrounded the contradictions that are prevalent within these liberal concepts and how we have to constantly work through them. And I was absolutely thrilled to see this bar dance illustration that you closed with, because very uncritically, constitutional morality, transformative constitutionalism, and other such concepts are embraced as automatically emancipatory. So I think this is what you have pushed us to reflect on, as also that we can't understand constitutionalism without having a critical conception of the state. We can't understand it without having a critical conception of rights, public versus private spaces, vertical or horizontal application of rights, and so many other things. I'm not going to take too much time, but because I'm moderating, I will take the privilege to ask my first question, and then we will open it up for everyone. I will hold on to that privilege. So, sir, my first question is with respect to ecology, constitutionalism and ecology. And I'm asking this in the backdrop of the climate, the Scotland conference that has just ended, and Greta Thunberg said that it can be summarized as blah blah blah. But so how do we actually talk about ecology? How do we actually talk about climate change? How do we talk about planetary rights within the scheme of Indian Constitution? I also say this because parallelly we are seeing in Latin American countries like Chile, there has been a sweeping change in the understanding of constitution, keeping in mind ecological rights. So first that, and secondly, I want to, if you could talk a little bit more about, you talked about short-term passions of the government and long-term passions of the government too. But, um, so how constitution as a document and constitutionalism are also connected to political emotions that we are witnessing more and more in around us, in public institutions, of course, in private lives, yes, but even in public institutions. So yeah, that is all. And then
Okay. So before I could respond to what Latika asked, just I want to put a caveat here. I'm neither BJP nor Congress, nor to any other political party. I use these because we are being a constitutional law students and disciples, we would say, that to really understand the constitutional principles, we need to take these kind of discussions. Please don't take any offense when I say something, but I'm just raising these issues to think ultimately you need to decide for yourself. To start with, one is the first thing that she asked is how do we, the Constitution, respond to the ecological issues? Now, this is one of the reason where, for example, in America, the Constitution never spoke about anything. It is just 7 articles, but still it is continuing. And when our Indian Constitution came again, ecology was not even in our reasonable contemplation of the constitutional makers that would become an issue. Because we never expected that the ecology could be linked to Article 21 those days, right? So now it is linked. And maybe a few amendments here and there into directive principles of state rights. One thing as a constitutional law teacher, I look at it is that it is not necessary that everything to be in the Constitution, right? Constitutions are worded such a broad manner so that everything could be covered under. Why did we say right to speech and expression? Nothing else. We never defined what is speech. We never defined what is wrong. So therefore, the problem is I am also not very much convinced that it is the Supreme Court which is going to protect our ecology. It's not going to. So unless I think I should have put that quote from Einstein. He says, Constitution is as good as its citizens. If the Constitution is strong, it means their citizens are strong. And Constitution is a good Constitution, means the citizens are good. So there is no good Constitution, there is no bad Constitution. It is all we. So it all depends upon how we perceive that ecology, how important is that ecology. Unless that is imbibed with us, I don't think we will be able to do that. And as long as we are not able to do that, our politicians will not do it. Reason is politicians are nothing but we. They come from the same society. So therefore, yeah, constitutionally we can debate. And particularly with the globalization, we say that there is the globalization of constitutional norms across the world. Because every constitution will have a rule of law, every constitution will have rule about equality, etc. But would constitution itself will sustain the ecological changes? I don't. I think it has to be from us. Coming to the second one, constitution talking about short and long term, yes, that is going to be an issue. But problem here is, for example, let me see, a political party has its ideology. It has its distinct ideology. Good, bad, we are not the one to judge. So if I have a political party come up with an agenda of these things and go to the election and win the election, but unfortunately the provisions of the constitution is to some extent against my ideology. Now you cannot promote those ideology also violates my political rights under the same constitution. Let me give you this an analogy. For example, a prime minister is a Hindu. Do he has a right to go to temple and pray like any other ordinary individual? Because the constitution gives him such power. But if we go to a temple every time and go as a prime minister, also gives a wrong signal that it is a Hindu state. If you
Professor, I think we lost you. We can't hear you. We can't hear him, no?
Oh,
Like,
no,
or
no,
is it? Yeah,
there's some problem
we
on his
can.
end.
Yeah. I think there's some glitch at his end. He'll just come back.
am I audible? Yeah, okay. So that is why if you look at the directive principles of state policy are supposed to be the guiding lights for the state to make them. Hence, the political emotions would continue. Ultimately, it's a transition period. People will realize which is correct. See, for so many years, liberal thought is a fashion. Later, it has changed. I'll give you an example. When I was in 10th standard, atheism is a fashion. Criticizing God is a fashion. We are swayed with that ideology because the people used to come and teach how religion is bad. Come to 90s, promoting religion become fashion. Right? It's the phase in the manner. So ultimately, it is the society which will decide whether the political emotions are correct or not. And they are going to stay. So before that, there are two questions were asked. Amit has asked whether positive constitutionalism and modern concept of rule of law are one and the same thing. I'm not sure, because unless the modern concept of rule of law also imposes the positive obligation on the state. My understanding of rule of law is talking about equality before law, everybody is subjected to the same equality, etc. But my worry is that may not be enough. State saying that in public sphere equality is sufficient is not enough. That's why I have not discussed that public and private sphere differences. I have not talked here because that takes an hour and a half to understand. So the rule of law promotes equality in public sphere. It doesn't promote equality in private sphere. So I don't think that would be sufficient. And I think that's the one. There is one more. Yeah, there is one more from Harshita. Religious perceptions also varies from person to person. Religion was created by humans, so the public perception. Yeah, that is one of the fundamental reason why we can't go by your public morality. At least constitutional morality is what constitution says and interpreted by the 36 judges. But when it comes to religion, 1.3 billion people will be interpreting what is public morality. So after the Shabarimalai case, at least I have debated with myself 6 months before finally coming to the terms. In addition to talking to some of my colleagues, whether we should go with constitutional morality or we should go with social morality. So finally, I thought maybe constitutional morality is less evil compared to a public morality. That is how I made peace of my mind. I still had doubts about that, but still it is. Give a new God in the form of constitution. I don't want constitution to be God. We need to discuss constitution, defile constitution, dissect constitution, which we cannot do with the God. Yes, constitution should be a way of life. That should be a way. I agree. Any more questions? Okay.
Sir, I have a question. In fact,
Yes.
I just want to know that what is the constitutional perspective or constitutional remedy rather with respect to the situation that we are facing for years together, that political elected people's representative are actually behaving like an agent of the principle of a political masters, chiefs. So what is the remedy to that? Because why I'm asking this, we know the practical perspective, because my child asked me, he's studying in class 7. He was studying that it is the CM to be elected by the elected representatives, by
Okay.
MLAs. But at the same
Yes.
time, in the TV, it is running of the Punjab that political chiefs are, engaging into deciding the CM. So he asked, "What is this, Papa? What to do?" So that's why I am asking, sir, what is the constitutional remedy and perspective in this regard, sir?
See, first of all, to talk about the appointment of the chief minister, constitution is nothing to do. It doesn't talk about political parties. It simply says the majority party. It doesn't even say majority party leader should be the chief minister. It simply says chief minister to be appointed by the governor and the council of ministers on the advice of the chief minister. But because we follow parliamentary democracy, it is a customary convention that the the majority party leader would be the leader. But when it comes to the party system, that is where you need to explain to your child. Maybe I don't know whether she would be in a position mature enough to understand. The party systems are different. Like like Ambedkar says, we don't have a democracy. We think that we are in democracy, but we are not actually in democracy. And how to put the political parties under the constitutional constraints is a challenge. That is what we discussed. Now, as long as we have this psychophancy to a particular leader, we have seen wherever there is a strong leaders, Indira Gandhi, N.T. Ramarao in Andhra Pradesh, Jayalalitha in Tamil Nadu, Narendra Modi now. So these are all strong leaders. When the strong leaders are elected, it has a impact on its political party. They become larger than the life. So that's why in most of the political parties where an individual becomes stronger, these tendencies would be more, right? So that is why if you see the number of cases, for example, I am from Andhra Pradesh and I knew when N.T. Ramarao became chief minister, he was he was a movie actor. Within 9 months, he started his own political party, and he won two-third majority. It's 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 a record in a politics in India. He's a good man, not a bad man, but he is autocritic. In his whole life in the movies, he is a superstar in Telugu. So he is an Amitabh Bachchan to Hindi. He's more than Amitabh Bachchan to Hindi in Telugu. So whatever he says is the right. So he tells the people who are running the government that he want this means he want this. Decide. So then these things are challenged in the court, and number of cases were filed against him. And then he used to say, I'm trying to do something good and the courts are not allowing. The same narration Indira Gandhi did during 70s, right? The courts are not allowing me to do it. I want to do nationalization of the banks. I want to bring you the land reforms, etc. Garibi hatao, they are not allowed. So all these things comes to the same back to bite us, that we as a citizens don't understand constitution and don't imbibe the constitution values. Unless you do that, this is going to continue. It will continue, and any number of cases will not stop. If you look at the present Andhra Pradesh government, more than 160 cases went against the government within the span of 2.5 years of the rule. So that shows that the politically you don't understand what is the constitution and constitutional constraints. This is what it is. So therefore, that is why we need to inculcate the constitutional values. And unfortunately, we study constitution for passing 50 marks in the LLB level. That's the problem. We really realize the value of the constitution only when you reach LLM, somebody talks about it. Otherwise, you teach constitution in the second year of 5 years course, hardly 19, 20 years of the students, they have no maturity to understand the institution. And that's why we say what is
any
wrong.
possible
Sorry, go ahead. Go ahead.
is possible remedy to this fundamental defect of this democracy within the gambit of this constitution? If anything you can place.
That is where your educational system is supposed to make you to think. And unfortunately, if you see, it is exactly going opposite. You see that the students get 100 marks out of 100 in English and social sciences. Ridiculous. I think those institutions should be blacklisted. How come? Because they don't allow us to think. Till 12th standard, the students were asked to by heart and write exactly the same. Like you eat and vomit on the answer sheet, and it is exactly the same, you get marks. And I have seen some of the teachers penalize the students for writing an extra information. So, and then once they join in the law college, you are telling them to think. For 18, 19 years, they never thought anything. Now you are telling them to think. So that education system need to change. And the educational values needs to change. That's why you remember one of the reasons why we want constitutionalism is constitutional values as an educational value. Constitutionalism as an educational value. That is what we required. And I could see there are many even constitutional teachers. Their understanding of the constitution baffles me. There were even they divided based on their political ideology rather than the constitutional principle. That's unfortunate.
Sir, thank you for a very enlightening session. And sir, I want to ask, like, in Indian Supreme Court also there is more, very much role of personal says, like we do not have, in a sense, some scholar says single constitution. We have, I mean, single Supreme Court. We have 31 Supreme Courts. I mean, each individual, each judges to his own notion. They are deciding the cases. Some are pro government, some are pro industry, some are pro environment. So different takes. So I mean, they need, there is a need of check and balance inherent. I mean, within the system itself, and sometimes Supreme Court also goes missing, like in the we have seen in the COVID and other different situations. So I mean, how you see institutions' role, judiciary role, and constitutional vis-a-vis these situations, sir?
Gurmeet, that is the question in every person's mind. But for that, first we must understand the limitations of the court. First thing is the court or the judiciary separate from the state? Though Article 12 doesn't talk about it. But politically, it is part of the state. So judiciary is part of the state. And that's why if you look at the major policy decisions were never struck down by the Supreme Court. What happened to demonetization case? We don't know. See, they didn't say yes or no. They simply put in a back burner, right? So an Ayodhya case can be decided, but not this. So therefore, one thing we should always understand that don't put too much trust on the judiciary, because judiciary is also an organ of the state, number one. And number two, even if the Supreme Court can do something, but it has its limitations. What is the limitation? It has no enforcement mechanism. If you see the series of judgments given by the Supreme Court regarding making all public transport into CNG conversion in the 1990s during in Delhi for pollution, to stop the pollution, how many orders the Supreme Court has to pass? And I still remember in one order, the Supreme Court said If you don't convert and if you run on diesel, you have to pay 500 rupees fine. And government paid that 500 rupees fine for every bus and ran the bus. So ultimately what happens is, unless there is a strong legislature and strong executive, a strong judiciary is useless. See, when we have both the hands, each hand has its utility, right? Because this fellow is not working, we want to strengthen this fellow. Now, this fellow is not in a position to perform what this fellow is supposed to do. Right to education. The amount of mess the judiciary is created, you could see right from Mohdi Jain's case onwards. Supreme Court is trying to micromanage medical education. Is that possible? But unfortunately, nothing can be done because the executive is not ready to do it. So we are running to the court. The court is telling even that NEET is compulsory, fix the dates. So these are all executive decisions. See, the judiciary has no attachment with the society. The ground realities of the society is known to the legislature and the executive. Therefore, the policies are supposed to be framed by them. So unless we strengthen and see that the legislature and executive are good people, occupied by the good people, judiciary will never able to do it. So therefore, if you have that illusion that the court is going to do something, not possible. That's impossible. So therefore, whoever is praising the Jai Bhim case, Jai Bhim is one of the cases. Like that, there are hundreds of cases in every state. So my take is, if the government officer is sensitized and trained properly in rule of law, one public officer is equal to 10 courts. He will reduce the burden of 10 courts if he properly exercises his duty. Because the people has access to the executive, not to the judiciary. So your sarpanch, your revenue officer, at the lower lung level people, these are the people who require the training. In fact, in Goa, my college is actively involved with the government in training those people. Not only, they train in all aspects. Recently, they finished the Deputy Superintendent of Police 45 days of training. And not only constitution, even in the financial matter, even general administration, how to talk to the people. So that is where the problem lies. So problem is here. We are looking at here to the court. So unless you strengthen your executive and legislature, nothing is going to happen with judiciary. It's impossible.
Thank you, sir. Thank you, sir.
And
morning, sir. I have a question, sir.
First also, to have, at least if the government makes their hearing. Okay, is any questions, or we will?
Yes, sir. I have a question, sir. If you permit, may I ask you a question, sir?
Yes, please
Hello,
go
sir.
ahead.
Am I audible, sir? Hello. Am I
Yes, you're
audible, sir?
audible.
Yes, Amit, you are audible. Please go ahead.
Yeah, yeah. Thank
Hear
you.
you.
I just want to ask you the
What?
constitutional justification
Voice
behind
is
the doctrine.
very low.
Amit Raj, can you please be a little louder? Maybe come a little closer to the mic.
Yeah. Now you are audible.
Yeah, sir. I just want to ask you the constitutional justification behind the doctrine of manifest arbitrariness. The constitutional justification behind the doctrine of manifest arbitrariness. It was it was reinforced
What
by,
he said.
if I remember correctly, Justice Nariman in Saira Banu case, where Justice Nariman has of the opinion that legislative enactment can also be checked on the ground of arbitrariness. So in my opinion, sir, does it not amount to entering into the legislative wisdom by the judiciary? because like what the law is to be made, how it is
Yeah.
to be made, it is complete discretion of the legislature, and that is the constitution has authorized. So when you allow judiciary to test the legislative enactment on the ground of arbitrariness, so isn't it the violation of the doctrine of separation of power? Thank you, sir.
Yeah, if you look at, now you need to read Article 13, which clearly says you cannot make any law violating fundamentals. Okay, 13 clause 2 is very clear. Now, under 14, we already developed this concept of reasonableness. Now, what the Supreme Court, starting from Maneka Gandhi case onwards, said is, if the legislative action or the executive arbitrary, Article 4, you bring it, but law is reasonable under clause 2 concept. Look at the Air India versus Nargish Mirza's case. We already looked at that a woman air hostess is the law. A woman air hostess cannot become pregnant. Once the moment she becomes pregnant, she has to resign from the job. It's a law, and that law is arbitrary. Hence, it could be challenged and it should be struck down by the court. I do agree with you that the court cannot make a law, though it does make sometimes, but the court should not make a law, because if the court makes the law, there is no judicial review for them. That is the biggest problem with the court making. So if a law is made by the legislature, it is in the form of a bill, and the bill is
Are you?
No, sir,
So
your
I
voice
think,
is breaking.
sir, we are losing your voice.
discussed in the parliament.
Sir, we lost your voice, sir. Can you please repeat?
So towards the end, we lost you.
Both the houses for voting. Sometimes they send it for privilege committee or select committee. Right now, can you hear? But now you can hear.
Yes, sir.
Yes, sir, we can hear you.
Yes?
Yes, sir.
Yes, sir. Yes, sir.
Okay. What I'm saying is, if you want to make a law, there is a process. Like bill is prepared, put in Lok Sabha passes, sent to, or maybe somebody raise an objection, then goes to Rajya Sabha passes or rejects, then goes to president gives. So there is a process. And then if you don't like the law, you go to the court. But if the court makes a law, first of all, it is circumventing the entire principles of legislative process. And the most important is, if the Supreme Court itself says this is the law, how do you challenge whether it is valid or not? Because it is my law, I may not be able to decide it. Okay, so I agree that this, as far as possible, this court should not make the law, but the court should be able to interfere with the law if it is arbitrary. But again, what is arbitrary depends upon the judges. I agree. Unlike America, where all 9 judges sits, but America is not a rousing picture, because they also, who are the Republican judges, who are the Democratic judges, how they decide, that is also a problem in America. Right? They are all worried now that Roe versus Wade will be going now, and abortion may be rejected now. That's what they were thinking. So that is always happens because judges are human beings like us. They have weaknesses like us, they have prejudices like us, they have problems with like us, perceptions with like us.
Thank you.
Do we have any more questions or comments? No. Okay, sir. So I think we are through, and maybe like we'll bother you with emails, and we will definitely bother you again for more such talks. You've given us so much fodder to think about and to read. So we would definitely want to invite you again, sir. And please take out time,
Sure.
and interact with us. Maybe like again like in an online way. So. With that, I would want to take the opportunity of thanking you and saying that we really miss you at ILI, sir. So next time you come, you should let us know.
I do miss ILI too. I do miss ILI.
Yeah.
I got a great
Yeah.
students.
So with that, sir, like I will not take further of your time. Thank you, everybody, and we'll meet again. Okay, in the
Yes.
next talk. The next talk, we will continue this conversation that we have started with Professor Prasad today. In the coming few weeks, we will have discussions on gendered constitutionalism. We will also be talking about privacy jurisprudence of the Supreme Court and its impact on family law. As also the questions of governance within constitutional framework. So this, and I'll keep you posted on that. So thank you, sir, and we hopefully will stay in touch.
Thank you. Thank you. Nice to see you, Amit. Gurmeet, I already said. Thank you all. Thank you, Latika. Thank you.
Bye-bye.
Thoroughly
Bye, sir.
enjoyed.